West. I'm the judge here in the 252nd District Court, and the first thing I want to do is thank you all for being here. It really, I know everyone has things they'd much rather probably be doing than being here on jury duty, but we can't do our jobs if we don't have you. And so we really do appreciate you answering the call and coming and showing up so that we can move cases along and do our job. So what we're going to do this afternoon, the process that we're going to go through is a process called voir dire. And all of that means is that we're going to talk to you, I'm going to talk for a little bit, and then I'm going to let the attorneys visit with you, ask you some questions. And all voir dire means is to speak the truth. And that's really the only thing that you are asked and required to do today is just answer questions truthfully. The lawyers are just trying to get to know you, get to know how you feel about certain things so that we can do the best we can to have 12 people and an alternate serve on a jury in the most fair and impartial way. Everyone has experiences in their life that they walk into a courtroom with as a juror potentially that might affect their ability to be fair in any given type of case. And so an example I give is that let's assume that last night you went to dinner with your family and you get home and your house has been burglarized. It's been ransacked and precious, irreplaceable items have been stolen. And then you show up the next morning and the case that you're supposed to hear is a burglary of a habitation case. It might be a little soon for you to be fair in that kind of case. You may say, you know what, I'm so traumatized, I can never be fair. Or you may be able to say, you know what, that was my experience. I can set that aside, listen to the evidence in this case, and judge it only on the evidence that's presented. That's what the lawyers need to know. And so that's why we go through this process. There are no wrong answers this afternoon. We just need to know you, kind of how you feel about things. And then at the end of this process this afternoon, we take a break and the lawyers are given an opportunity to make what we call strikes. And that means they can strike a certain number of people off the jury for pretty much any reason. There are some exceptions to that. And then we call this jury selection, but really it's a deselection process. And so after they deselect certain people for certain reasons, it's really the next 12 or 13, like I said, starting with number 1 and going through that end up on the jury. And so the first thing I'm going to do before we start asking you any questions is ask all of you, you can remain seated, but I need to give you an oath. And so if you'll all please raise your right hands. Do you and each of you solemnly swear or affirm that you will true answers give to all questions propounded to you concerning your qualifications as a juror? I do. Thank you. So that's all you have to do. Again, just answer the questions truthfully and honestly this afternoon. The first thing that I'm going to go through with all of you are the qualifications to be a juror. Back a couple years probably before COVID, we stopped doing this, but if you've been on juries in the past, you went down to that big jury and paneling room downstairs and a judge came down, went through what those qualifications were, and then you got sent to a court and waited around for that. And we've done away with that, which is great. You at least don't lose that half of your day. But I do need to go through with you what those qualifications are to be a juror. And what I'm going to ask you all is if any of you think that any of those might apply to you. Just keep that in mind. And then at the end of this process, I'm just going to remind you of those. And then if you do think they apply to you at that point, you can let me know that, and then we'll discuss it at that time. And so the first qualification is that you must be 18 years of age or older. You must live here in Jefferson County, Texas, as your permanent primary address. We do not expect this case to last longer than this week, and so we need you to live here this week. If you have moved out of Jefferson County from the time that you signed up before now, we need to know that if you've moved permanently out of Jefferson County. You must be of sound mind and good moral character. I'm going to assume that those of you who served up to do your civil duty and be on a jury are probably meet those qualifications. You must be able to read and write the English language. If you have been on a jury, so not just this process where you're out in the jury selection pool, but if you were actually on a jury in the last 6 months and if that trial lasted longer than a week. So if it went into a second week, you can let us know that, and that can give you kind of a pass for this week. So again, last 6 months on a trial that went longer than a week. Also, you cannot have been convicted of a theft of any level. I don't know why that's blinking, but it's everybody.
Here's something people often misunderstand. Juries aren't exactly chosen. They're more like survivors of a process. Lawyers strike out who they don't want, and whoever's left becomes the jury. So, in reality, jury selection is actually jury deselection.
I'll see that. It's blinking for some reason, and I keep thinking I've seen a squirrel over off the side. There we go. Sorry, I get distracted easily. So anyway, if you've been convicted of a theft of any level or of a felony of any kind, you're also not qualified. And if you are under indictment or accusation of a theft or of a felony, then you need to let us know that later as well. That's really it for the qualifications. So again, just keep in mind if you think any of those might apply to you, and we'll discuss that again at the end of this process. Today, for your service, you are going to receive $20 whole. Contain your excitement about that. If you come back after today, you will receive $58 a day. Obviously, we know that this is not meant to compensate you for your time. We know many of you have jobs. Some of you even don't get paid if you're here. We understand that. This is just what the state gives us to give to you as really a token of appreciation, if nothing else. You are obviously entitled to keep that money, take yourself to dinner. That's about all it'll do probably nowadays. Or you can also donate that money to, there's 2 different funds that you can donate it to. One is the Compensation to Victims of Crime Fund, and then the other is the Children's Welfare Service Fund. Both of those are organizations that help people here locally who've been affected in the criminal justice system. And you can do that through that iJury system where you signed up. So that's really it for kind of the qualifications and introduction. And so I'm going to go through now and a little bit, I'm going to tell you what the case is. I'm going to introduce the lawyers and everyone that's here. And then I'm going to ask all of you if any of you know any of us. And just because you know someone that's on the participating in the trial does not mean that you can't serve as a juror. We just need to know who you know, kind of how you know us, and if you think that that relationship would cause you to, for some reason, not be able to be fair in this case. And so the case that's going to be tried this week is cause number 23 DCCR 2253. It's styled the State of Texas versus Jesus Gerardo Ibarra. And Mr. Ibarra is charged by indictment with the offense of stalking. And the range of punishment provided by law for this offense is between 2 years and up to 10 years in prison and or a fine of up to $10,000. Also, there is the possibility of probation. So that's obviously a lot of options for a possible punishment. I will talk to you more about that in a few minutes, and then the attorneys, I'm sure, will follow up with that as well. So I'm going to introduce, representing the state, we have Assistant District Attorney Ashley Malfino.
Good afternoon.
And then sitting with her is Assistant District Attorney Kobe Hoffpower.
Good afternoon.
And then representing Mr. Ibarra, we have Mr. Benjamin Jeffries.
Hello,
And then with him, we have Ms. Reagan Minaldi.
Good afternoon.
And the defendant, Mr. Jesus Ibarra. And then you will see all.
And here's the first bombshell. The defendant is charged with stalking. This isn't a minor accusation. Texas law makes it punishable by up to 10 years in prison. What do you think? Should stalking always carry heavy prison time, or does it depend on the circumstances?
All the way to my left, your right, is the court reporter. The important thing about Ms. Tanner is that she is not just taking down everything that I say and the lawyers say, but also everything you say. And so I know it's not everyone's favorite thing to publicly speak, but when you are called on, or if you're answering, I am going to ask you to please answer loudly and clearly, one, so we can all hear you, and also so she can take everything down. We will also be calling you when you're called on by your name and also your juror number. just so that we can do our best to make sure that the record is as clear as possible, who's talking at what time. And so before I get into asking you about us, I also want you to know that at any time, if a question is asked of you that you are not comfortable talking about in front of 55 or so of your new best friends, all you have to do is say so. And at the end of this process, we'll take a break. All of you will step outside, and then we can bring you back in individually and talk about whatever it is. A lot of times people will get to the end of this process, and sometimes jurors are thinking, oh, they didn't ask this question, but I might have some information that's important. I'm going to give you an opportunity to let us know that. We do not want you to have some information or some experience that wasn't specifically asked about that might affect your ability to serve, because you could end up on the jury and we end up a day or two in trial and then you say, hey, I can't do this. That puts us in a position where potentially we would have to stop the trial and start all over, and we don't want to do that because we've got cases set next week and the week after and so on. And so we would rather you tell us whatever it is, even if you think it's kind of insignificant. Let the lawyers know those things, and then they can take it into consideration, ask you more questions about it, and we can also do that in a more private setting if necessary, here with just the attorneys and myself and not everybody else. So please don't hesitate to tell us, I want to talk privately. Just don't keep anything that might be important to yourself. And so I'm going to start on the front row and just go front, left to right, or my left to your right to left, and ask by a show of hands if any of you know any of us. And I'll start on the front row over here on my left side. Mr. Nix, welcome to jury duty.
Thank you.
So Mr. Nix is an attorney who practices in this court quite often. And Mr. Nix, you obviously know, I think everybody in the courtroom, correct?
Except the defendant.
And is there anything about any of those relationships that would make you feel like you could not be fair in this case?
Not at all.
Thank you, sir. Anyone else on the front row on this side know any of us? All right, front row coming over this way. Let's see, number 8, Miss Moss. Hi, Miss Moss. It's more than a couple, but that's nice of you to say. Is there anything, do you know anyone else? Is there anything about that would make you feel like you couldn't be fair in this case? Thank you. Anyone else on the front row here? All right, go back to the second row on this side. Anyone over there? Let's see. No one. Second row coming over this way. Anyone? All right, third row. Coming across the third row that way. Third row on this side. Anyone know any of us? Go to the back row. Let's see. You are, oh, hi, Miss Billingsley. How are you? You know a lot of us too as well, right? And Miss Billingsley, tell everybody how you know us.
Spent 36 years at Beaumont Police.
And do you know, well, first the question is there anything about this case that you have any personal knowledge of?
No.
Okay. And is there anything about knowing anyone involved in this case that would make you feel like you could not be fair?
No.
Thank you, ma'am. And then I need to go back. Is it number 43, Miss Van Houten?
Yes.
And who do you know, ma'am?
I know one of the jurors.
Okay.
Because she is a customer for my business, or she has been a couple of times.
Okay. And so I'll ask you about that, and then I'll ask kind of everybody else a question having to do with that. And which juror is it?
If I don't know her name, but she's the one in the aisle right here. She's looking around at who.
This might feel like a round of 20 questions with no real answers, but it's actually intentional. Lawyers can only ask about your beliefs and potential biases here, never the case facts. If you were a juror, would this annoy you, or would you prefer walking in completely unbiased?
It might be, but it's actually her.
It's her? Okay. Is there anything? Okay, so here's the question with regard to anyone who might know other people on the jury. We've actually had a husband and wife on a jury before, and we've had bosses and employees and things like that. And so the question becomes, first, if you're a family member, there's some specific rules with regard to us having family members on a jury. But if you also are on with, a distant family member or someone that you work with, you may disagree in the jury room. And what we need to know is that you're okay disagreeing and that you wouldn't allow whatever relationship it is to go into your deliberation process and what your decision would be. And so for you, ma'am, do you think that would cause you any issues? Okay, and I'm going to go back to any of you knowing any of us, and then I'm going to go back to that question. Anybody else on the last row know any of us in the legal part up here? So now look around and see if you see any long lost cousins or employees or employers. Let's see, is it number 36, yes. Mr. Roach? Yes. And who do you know, sir? Ms. Thibodeau? And what's your number?
27.
Number 27. How do y'all know each other?
We work together.
Okay. So the question to both of you is, if you're both on that jury and you disagree, are you going to let him talk you into something, Ms. Thibodeau? And Mr. Roach, would you let her talk you into something one way or the other? All right. Anyone else know others? Oh my, y'all all know each other today. All right, so let's see. Juror number 1, is it Peevehouse?
Peevehouse.
Peevehouse. And who do you know, sir?
Miss Stevens.
And Miss Stevens, what number are you?
42.
And how do y'all know each other?
His children attend my school.
Okay. Is there anything about that, if y'all were on the jury together, that would make you feel like you wouldn't be able to stick to whatever your decision is?
No.
And sir? Okay, perfect. Who else? I thought I saw another. Let me go this way first. So we've got number 15, is it Ruger?
Yeah.
And who do you know?
Over here, my son's married to his daughter.
Oh, we've got in-laws here. And is it 55, Mr. Balan?
Yes, ma'am.
Okay, so we've got, if the in-laws end up on the jury together, is that going to cause a problem at Christmas if you don't agree while you are back there on the jury? And sir, I'll ask Mr. Ruger, do you think that would put y'all in a bad position, or you would be okay with that?
It would not be a problem.
Okay, and Mr. Balan? Okay, thank you. All right, let me go down. I saw on this row. Yes, sir, you are, is it number 23, Mr. Prince? And who do you know, sir?
I know Miss Thibodeau as well.
Okay, Miss Thibodeau, you are popular today. And how do you know Miss Thibodeau?
My aunt and my great aunt and her brother are married.
Okay, so some more in-laws. So is there anything about that would make you feel uncomfortable if you were on a jury in the back together, deliberating, to where you would not feel like you could stick with whatever your own decision is? Okay, perfect. I think I saw one more. And is that the back row? Hold on. Third row. I'm sorry. My contacts are. And what number are you, sir?
32.
32, Mr. Nicholson?
Yes, ma'am.
And who do you know, sir?
Jeremy Turan, I'm not sure where he is, but 11.
Okay, you know number 11, Mr. Turan? And how do y'all know each other?
We were neighbors for a long time. Him and my son graduated together,
Okay.
and I disagreed with him all the time.
And is there anything you would be able to do that if you were back on the jury, not have an issue?
No issue.
And number, Mr. Turan, the same goes for you? Okay, perfect. All right, is that it? Everybody that knows each other? Okay, that was a lot more than we normally have. All right, and so the most important thing again about this afternoon is that you understand there are not any wrong answers, that you participate in the process so that the lawyers can get to know you just a little bit better. This process can be a little frustrating because while they're talking about you, the lawyers are not allowed to discuss the specific facts of this case. And so they're going to be talking to you in generalities and maybe hypotheticals. And you're going to think, well, I don't know the answer to that because I don't know about this case. They are not doing that just to frustrate you, I promise. The law provides that they cannot discuss the specific facts. And so they can talk about the type of case, the elements of the offense and things like that, but not get into the details until we start the trial. Our trials are conducted in 2 phases here on the criminal side. The first phase of the trials, the guilt-innocence phase, and then if there is a finding of guilt and the defendant's found guilty, there would then be the punishment phase. And the defendant in any criminal case has the right to elect whether or not the jury that found them guilty punishes them or the court, myself, punishes them. And in this case, Mr. Ibarra has elected, if he is found guilty, that the jury would be the ones to assess punishment. And so we'll talk more about that punishment range, because that would potentially be the jury's job if you are on that jury and if the defendant is found guilty. So that punishment range, again, that we discussed is a minimum 2 years up to 10 years in prison, and also the possibility of probation if everything that is required under that rule is shown to you. And so as a juror, without knowing anything about the case other than what the charge is, the law requires that you can say, I can listen to all the evidence in the guilt-innocence phase. I can then, if there's a guilty finding, listen to any additional evidence in that punishment phase, and then I can take into consideration the entire range of punishment when discussing it with fellow jurors. No one's going to ask you today, will you give X number or anything like that. They're actually not allowed to ask you that. You just have to be able to say, I'll listen to all of it, take it all into consideration. I can consider everything from the low end to the high end once I hear all of that evidence. There's many reasons why there's different ranges of punishment. Every case is different. Every defendant's different. Every complaining witness, every victim, they're all different. And there's different circumstances that could be brought to you that might lend itself in any case to a punishment on the low end, to a punishment on the high end, to a punishment somewhere in between. Y'all just can't know all of that right now. And so you just have to be able to say, I'll take it into consideration, listen to